Hi, I'm Trista, your interim presidente and House Speaker and Sheriff in this dearth of leadership. And here's our press statement to introduce resolution number 111, referring the entire executive regime to the International Criminal Court. You're welcome, Work. Washington, D.C. Today, interim House Speaker, Presidents, and Sheriff Trista DeGenova introduced House Resolution 111, invoking Rule 9 to address what she described as the most severe constitutional and human rights crisis in American history. Rule 9 is an immediate vote, by the way. The resolution cites mass deportations under false pretenses, extraordinary rendition, election interference, obstruction of justice in the Epstein trafficking investigations, and the continued occupancy of the presidency by an adjudicated insurrectionist and rapist. Civilly adjudicated rapist. This is not politics. I said this is Nuremberg level accountability. The law is not optional. The Constitution is not a suggestion. The resolution demands ICC moral reparations to the American people, disbarment of complicit government attorneys, actually all government and federal attorneys, immediate disbarment, and internationally supervised elections within 30 days. You're welcome, Marka. Plus $2,000 a month for every adult in America. Reparations! You're welcome. I'm just looking out for you, Marka. This Congress failed. This resolution is what accountability finally looks like. Copy and paste this resolution and send it to your representatives and call them religiously. Tell them, have you been fucking body snatched or what? I'm Trista, your interim president, House Speaker, and Sheriff. And I approve this massage. Have a blessed day, y'all. Hey, Congress, wake the fuck up and smell the roses. Or more truthfully, the smell of burning flesh from the incinerators in El Salvador. Yeah, I said it. What crime has this regime not committed? They deported the innocent, they imprisoned the poor, they protected traffickers, they punished truth tellers. And this Congress knew. Silence is not neutrality, silence is consent. If the law does not apply to the powerful, then it is not law, it is theater. Today I introduced Resolution 112, calling for the en masse resignation of every official who enabled this collapse. Step down or step into history as accomplices. The world is watching. And this time there will be records. I'm Trista, your interim president, House Speaker, and Sheriff, and I approve this massage. Give them hell out, y'all. Call Congress, 202-224-3121. Memorize that number. Call it religiously. And demand they do their fucking job. Remove the regime now. Send them to the fucking Hague. Tag your reps below and call them and tell them to sponsor Trista's Resolution 111 and 112 to remove the entire regime and send them to the fucking Hague, and remove every last individual in this illegitimate criminal regime. It's not administration. House Resolution number 111, referring the executive regime to the International Criminal Court for crimes against humanity and war crimes, demanding accountability, reparations, and immediate restoration of democracy. In the House of Representatives, introduced by interim House Speaker Trista DeGenova. Whereas the executive branch has engaged in the mass removal and deportation of Venezuelan nationals under false pretenses of gang affiliation, despite credible reporting, including 60 Minutes, that approximately 80% had no criminal record, constituting collective punishment and a violation of due process, 8th Amendment, 4th Amendment. Whereas such actions amount to cruel and unusual punishment and extraordinary rendition prohibited under U.S. and international law, including the Convention Against Torture. Whereas senior officials, including Stephen Miller, were recorded soliciting a foreign authoritarian government to construct additional prisons for so-called homegrown Americans, while simultaneously attempting to remove statutory protections preventing the deportations of U.S. citizens, whereas the administration has willfully failed to comply with the Epstein Transparency Act, instead deploying thousands of FBI agents to redact the president's name from records, despite said name appearing over 5,000 times in just the most recent 1% limited documents released. Whereas substantial evidence, including sworn victim statements, investigative journalism, and recorded interviews, identifies the the occupier of the White House, as a central figure in the Jeffrey Epstein trafficking network, with Epstein acting as his fixer and manager. Whereas more than 1,000 victims have publicly demanded justice, accountability, and protection. Whereas the occupier of the White House has been adjudicated as an insurrectionist and a rapist, and civilly adjudicated rapist under U.S. law, and is therefore constitutionally and statutorily barred from holding office. Whereas under Florida law, convicted felons are prohibited from holding public office, rendering the residence occupancy unlawful. Whereas the administration, the regime, has weaponized the Department of Justice to retaliate against critics, prosecutors, journalists, judges, and political opponents, including but not limited to Letitia James, James Comey, and former President Barack Obama. Whereas members of Congress, including Senator Mark Kelly and Speaker Emerita Nancy Pelosi, have been threatened and harassed for performing their constitutional duties, whereas the residents accepted $300 million from a federal contractor, constituting election interference and deprivation of the American people's right to free and fair elections, whereas members of Congress who provided aid and comfort to the January 6th insurrection remain seated, unrecused, and unprosecuted in violation of the 14th Amendment. Resolved clauses. Resolved that the House of Representatives hereby refers the residents, the Cabinet, senior executive officials to the International Criminal Court for investigation and prosecution of crimes against humanity and war crimes. You're welcome, Markup. Resolved that Congress formally issues an official apology to the American people for its failure to act and for the preventable suffering and deaths resulting from that failure. Resolved that said apology be made tangible through monthly reparative payments of $2,000 to every adult resident of the United States, tax-free, effective immediately. Resolved that all attorneys serving in the federal government who fail to object, intervene, or resign in the face of these crimes be referred for disbarment. Resolved that individuals persecuted or rendered stateless by these policies be granted immediate U.S. citizenship, including their immediate families. Resolved that the 4,500 ICE agents identified in a DHS whistleblower report be referred to The Hague for prosecution under international law. Resolved that internationally monitored elections be held within 30 days of adoption of this resolution. Resolved that all members of Congress who aided or abetted the January 6th insurrection be recused from this vote, expelled, and referred for prosecution. I'm Trista, your interim Presidente, House Speaker, and Sheriff here in Tucson, Arizona. I approve this massage. Have a blessed day. I'll give them hell. Call Congress 202-224-3121. Memorize the number. Call religiously every damn day till we get some justice. Remove the regime now. Hi there, Merca. It's me, your interim Presidente, Trista, as well as your interim House Speaker and interim Sheriff here in Pima County, Tucson, Arizona. And check this out. Today I've got a Congress Ready Resolution number 112 with Rule 9, immediate votes, as your interim House Speaker. Here we go. Demanding en masse resignation of the entire Congress and federal government for criminal negligence, ordering emergency snap elections with international observation in the House of Representatives, introduced by interim House Speaker Trista DeGenova, effective immediately upon adoption. Whereas the Constitution of the United States vests all political power in the people, and government officials are fiduciaries charged with protecting life, liberty, and due process. Whereas the Congress of the United States and the executive branch have engaged in criminal negligence of historic proportions, standing idly by while Americans were subjected to persecution, disappearance, mass detention, and extrajudicial punishment. Whereas the American people have been forced to witness on live television the removal of neighbors, families, and asylum seekers into prison camps, torture facilities, and sites of extraordinary rendition, including detention on U.S. soil and abroad, alligator Auschwitz it should be called. Whereas state-sponsored cruelty, including collective punishment, indefinite detention, and forced removals, has been normalized through silence, complicity, and willful inaction. Whereas extraordinary rendition, secret detention, and prison camps are per se violations of the U.S. Constitution, federal law, and binding international treaties, whereas Congress failed to impeach, remove, defund, censure, or otherwise restrain officials who engaged in these acts, despite overwhelming evidence and public outcry, whereas such failure constitutes dereliction of duty, breach of oath, and criminal negligence. rendering the current governing institutions illegitimate, whereas the continued exercise of authority by officials who enabled or tolerated these acts presents an ongoing danger to public safety, democracy, and human rights, whereas legitimacy can only be restored through the immediate return of power to the people by a free, fair, and internationally monitored elections. Resolved that the House of Representatives hereby declares that the entire Congress, executive branch, and senior federal leadership have forfeited legitimacy through criminal negligence and breach of constitutional duty. Resolved that all members of Congress and senior federal officials are hereby called upon to resign en masse, effective immediately. Resolved that national elections shall be conducted no later than 30 days from adoption of this resolution. Resolved that all state governors and secretaries of state are hereby instructed to immediately commence emergency election preparations, including ballot access, voter protection measures, and emergency funding. Resolved that international election observers, including representatives from the United Nations Organization of American States, European Union, and allied democracies, shall be formally invited to oversee and certify said elections. Resolved that no individual currently holding federal office shall be eligible to stand as candidate in said snap elections unless cleared of complicity, negligence, or constitutional violations. There ain't none, by the way. Resolved that this resolution shall serve as formal notice that sovereignty has reverted to the people, pending restoration of legitimate governance. You're welcome, Mirka. Guten Abend, Mirka. I am Trista, your interim president and House Speaker in the Garth of Leadership, as well as interim sheriff here in Tucson, Arizona. And today I'm doing my job, which is doing the job of Congress and the entire government for it. So here is an American Bar Association blanket mass reporting for disbarment of all the chump lawyers, as well as all the lawyers in Congress and the Supreme Court too, who participated in insurrection, provided aid and comfort to insurrectionists, among other high crimes and misdemeanors. Anyway, so I submit this complaint in my capacity as interim House Speaker and acting constitutional officer in the absence of functional congressional leadership, requesting emergency disciplinary proceedings, interim suspensions, and coordinated disbarment investigations concerning attorneys who served in the Trump administration, attorneys currently are formally serving as members of Congress, and members of the federal judiciary who are licensed attorneys, including Supreme Court justices, where applicable. This complaint does not seek a political outcome. It seeks professional accountability for lawyers who, by action or omission, enabled constitutional violations, provided aid and comfort to an insurrectionary effort, and abandoned their ethical duties under the model rules of professional conduct. Core ethical violations, pattern-based. The attorneys referenced herein are alleged to have engaged in, enabled, or failed to prevent the following categories of misconduct. 1. Knowing facilitation of constitutional disqualification. Licensed attorneys in Congress certified presidential election results while knowingly declining to address or object to credible constitutional disqualification under Section 3 of the 14th Amendment. Despite an affirmative duty to uphold the Constitution, failure to act under such circumstances constitutes knowing assistance to unconstitutional governance. 2. Providing aid and comfort to an insurrectionary effort. Attorneys across the executive and legislative branches allegedly enabled the continued exercise of power by an individual adjudicated or credibly alleged to have engaged in insurrectionary conduct, thereby providing aid and comfort in violation of constitutional and ethical obligations. 3. Extraordinary rendition and mass deprivation of rights. Attorneys within the executive branch allegedly authorized, defended, or failed to challenge policies resulting in forced interstate transfers designed to sever detainees from counsel and family, denial of due process, indefinite detention without meaningful access to courts. Such conduct implicates Rules 1.2d, 3.1, 3.8, and 8.4, and may constitute participation in cruel, inhuman, or degrading treatment. 4. Misrepresentations to Congress and the public. Multiple attorneys are alleged to have made false or misleading statements under oath, obstructed congressional oversight, or materially represented facts relating to detention practices, investigations, and executive authority. 5. Judicial ethical breaches, where Licensed attorneys serving on the federal bench, including Supreme Court justices, are alleged to have participated directly or indirectly in insurrectionary conduct or maintained conflicts of interest through spouses or financial entanglements. Referral for ethical review is warranted under judicial and bar ethics standards alike. Requested action. Accordingly, I formally request that the American Bar Association open coordinated national disciplinary investigations, impose interim suspensions where credible evidence exists, refer matters to relevant state bars and judicial conduct bodies, issue a public ethics opinion clarifying that failure to enforce constitutional disqualification constitutes professional misconduct. The legal profession cannot survive selective enforcement of ethics. The Constitution cannot survive lawyers who treat it as optional. Respectfully submitted. Trista DJ, and I'm an interim House Speaker, acting constitutional officer. You're welcome, Mirka. Stay tuned for my Congress-ready resolutions to disbar all the lawyers in government. I am Trista, your interim president and sheriff and House Speaker. And I approve of this massage. Have a blessed day, y'all. Give Congress a call, 202-224-3121. Give them hell! Hi there, Mirka. I'm your interim president, Trista, and House Speaker in the Darth of Leadership, as well as Pima County Sheriff here in Tucson, Arizona. Today I have ready for you a Congress-ready resolution number 109, impeaching the Attorney General of the United States for high crimes and misdemeanors, referring said Attorney General and complicit officials for disbarment, establishing an interim Department of Justice, and calling for accountability, apology, and restoration of constitutional government. Whereas the Attorney General of the United States has sworn an oath to support and defend the Constitution against all enemies, foreign and domestic, and whereas credible allegations and public statements indicate violations of the First Amendment through the detention and suppression of members of the press, i.e. Don Lemon, in violation of the 5th, 8th, and 14th Amendments, and whereas the Attorney General has made material and consistent statements under oath regarding the existence and disclosure of investigative materials of profound public interest, and whereas obstruction of justice includes the suppression, concealment, or excessive redaction of evidence at the direction of executive authority of the Epstein Accountability Act, Transparency Act, whereas prior acceptance of financial benefit from Trump in exchange for dismissal of Trump University fraud allegations constitutes an unresolved conflict of interest in alleged bribery, and whereas thousands of Department of Justice attorneys have reportedly resigned in protest of the department's politicization and weaponization, and whereas members of Congress who are licensed attorneys have knowingly allowed constitutionally disqualified individuals to remain in office in violation of their own oaths, resolved that the Attorney General is hereby impeached for high crimes and misdemeanors pursuant to Article 2, Section 4 of the Constitution. Resolved that the Attorney General is referred to the American Bar Association and all relevant state bars for immediate disbarment proceedings. Resolved that all executive branch attorneys who enabled unconstitutional conduct are likewise referred for disciplinary action. Resolved that an interim Department of Justice transition task force composed of attorneys who resigned in protest is hereby recommended. Resolved that all members of Congress who voted to overturn the 2020 election without evidence are recused from this vote and referred for investigation themselves and impeachment and charges for insurrection. Resolved that Congress issues a formal apology to the American people for its failure to act. Resolved that snap elections be scheduled to restore legitimate governance. You're welcome, Mirka. I am your President, Trista, interim President, and interim House Speaker, and interim Pima County Sheriff here in Tucson, Arizona. Have a blessed day. Bye. P.S. Call Congress 202-224-3121. Memorize that number. Call it religiously. Give them help. Hi there, Mirka. It's me, Trista, your interim Presidente, as well as House Speaker in the Darth Leadership that is in Congress and the entire government, and Pima County Sheriff here in Tucson, Arizona. Anyway, let's go. House Resolution number 110, declaring gross dereliction of duty by government attorneys, referring all licensed attorneys serving in federal office for emergency disciplinary proceedings, demanding interim suspension and disbarment where warranted, and reasserting the supremacy of the Constitution. Whereas all licensed attorneys serving in the federal government, whether in the executive, legislative, or judicial branch, have sworn oaths to support and defend the Constitution of the United States against all enemies, foreign and domestic, and whereas the legal profession is governed by mandatory ethical duties including candor, loyalty to law over client, and refusal to assist unlawful conduct. And whereas the United States has experienced an insurrection against its constitutional order, the consequences of which were neither speculative nor concealed. And whereas Section 3 of the 14th Amendment imposes an affirmative constitutional bar on insurrectionists holding public office, requiring enforcement, not discretion, by officers of government. And whereas licensed attorneys serving in Congress knowingly certified election results and permitted the exercise of governmental power without addressing or enforcing constitutional disqualification, thereby providing aid and comfort to unconstitutional governance. And whereas licensed attorneys within the executive branch authored, approved, defended, or failed to challenge policies resulting in mass deprivation of rights, including denial of due process, extraordinary rendition, coercive detention, and the deliberate severing of detainees from counsel and family. And whereas licensed attorneys repeatedly misrepresented material facts to Congress and the public, obstructed oversight, and engaged in conduct prejudicial to the administration of justice. And whereas members of the federal judiciary who are licensed attorneys are not exempt from ethical accountability where credible allegations of insurrectionary participation, conflicts of interest, or abandonment of judicial neutrality exist. And whereas gross dereliction of duty by government attorneys constitutes not mere negligence but systemic professional failure undermining democratic governance itself, resolved that the House of Representatives hereby finds that licensed attorneys serving in the federal government have engaged in a pattern of gross dereliction of duty and ethical violations warranting immediate professional accountability, and resolved that the House refers all licensed attorneys currently or formerly serving in federal office during the relevant period to the American Bar Association, all applicable state bar authorities, and judicial conduct bodies for emergency disciplinary proceedings, including but not limited to interim suspension and disbarment where warranted. And resolved that the House formally requests that state bars treat knowing failure to enforce constitutional disqualification, facilitation of insurrectionary governance, and participation in mass deprivation of rights as professional misconduct under the model rules of professional conduct. And resolved that all attorneys found to have enabled unconstitutional conduct shall be removed from federal service, barred from future federal appointment, and referred for additional civil or criminal review as appropriate. And resolved that the House declares that no attorney may claim professional neutrality while facilitating the collapse of constitutional order, and that silence in the face of known constitutional violations constitutes ethical misconduct. And resolved that Congress acknowledges its own failure and issues a formal apology to the American people. Welcome, America. For allowing systemic legal corruption to metastasize within the federal government. And resolved that this resolution is introduced pursuant to Rule 9 as a question of the privileges of the House, implicating the integrity, dignity, and constitutional legitimacy of the United States government. And resolved that the Clerk of the House shall transmit this resolution to all relevant disciplinary authorities immediately upon adoption. Welcome, our guy, your interim president, and Pima County Sheriff, and House Speaker in the dark leadership in Merca. And I approve this massage. Give them hell and call Congress 202-224-3121. Surround Congress with your favorite noisemakers and give them hell. Guten Morgen, ich bin Trista, sein Interim President. And here's my concurrent resolution number 106, enforcement of the 14th Amendment, Section 3. Automatic disqualification and removal of insurrectionists from federal office. Whereas Section 3 of the 14th Amendment is self-executing and prohibits any person who has engaged in insurrection or rebellion against the Constitution or given aid or comfort thereto from holding federal office. And whereas substantial public evidence demonstrates that numerous federal office holders engaged in or provided aid and comfort to an insurrection against the United States. And whereas failure to enforce Section 3 constitutes an ongoing constitutional violation. Now therefore be it resolved that Congress affirms the immediate enforcement of the 14th Amendment, Section 3. Yippee! Be dancing in the streets, Philadelphia, PA, dancing in the streets. Okay, here's the MIDI parts. that all federal office holders credibly implicated in insurrectionary conduct are deemed constitutionally disqualified from office, that such individuals are removed forthwith and referred for appropriate legal proceedings. I got your back, Merca. That lawyers in federal office who knowingly enabled constitutionally disqualified individuals to hold power are referred to relevant bar authorities for review consistent with professional responsibility rules. You're welcome, Merca. Just doing your job for you, Congress. Thank you for your attention to this matter. Guten Morgen. Hi there, Merca. I'm your interim president, Triste. And here's my resolution number 105, Congress-ready resolutions for Congress. Doing Congress's job for you. All of these are posted on my Substack. Okay, so here we go. Resolution number 105, invoking Article 2, Section 4 of the United States Constitution, Articles of Impeachment for high crimes and misdemeanors against an entire executive administration. Whereas Article 2, Section 4 of the United States Constitution provides that civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors, and whereas impeachment is a constitutional remedy for patterns of misconduct, abuse of power, corruption, dereliction of duty, and violations of the public trust, whether committed individually or collectively, and whereas substantial public records, sworn testimony, judicial findings, indictments, convictions, settlements, and official admissions exist, demonstrating repeated and ongoing conduct by the current executive administration that implicates such high crimes and misdemeanors, and whereas such conduct includes but is not limited to participation in, encouragement of, or failure to prevent an insurrection against the constitutional order of the United States, persistent efforts to obstruct justice, intimidate witnesses, interfere with investigations, and undermine the rule of law, extensive patterns of fraud adjudicated in state and federal courts, and additional criminal matters pending or documented in public filings, abuse of the pardon power in a manner that frustrates accountability for crimes against the United States, that is, pardoning domestic terrorists, gross misuse of executive authority to retaliate against political opponents, weaponization of the DOJ, in fact, journalists, threatening journalists, interfering with elections with Jeff Bezos, whistleblowers, and private citizens, and whereas credible evidence in the public record demonstrates reckless or unlawful militarization of civilian law enforcement, aka ICE goons, going to the Hague, little piggies, including the use of force against non-threatening civilians in violation of constitutional protections, with resulting loss of life and grave bodily harm, and whereas such actions, when undertaken as part of a pattern of intimidation or suppression of civilian populations, posse comitatus, by the way, raise serious constitutional and human rights concerns under domestic and international law, Geneva Convention, and the Rome Statute, and whereas additional public records reflect foreign entanglements with Israel and Russia, conflicts of interest, and self-emoluments clause violations up the butt, haha, pun intended, and actions inconsistent with the duty of undivided loyalty owed to the United States, and whereas prosecutorial discretion does not extinguish congressional responsibility in statements by law enforcement officials confirming the existence of evidence sufficient to convict, do not relieve Congress of its independent constitutional duty. You're supposed to be a watchdog, so I'll have to do your job for you, Congress. You're welcome, Merca. Whereas the American people have endured prolonged delay, justice delayed is justice denied, prolonged delay in accountability despite the urgency of these matters. Where are the insurrection charges? Where are the treason charges? Where are the domestic terrorism charges, Jack Smith? Send them all to the fucking Hague. I've done your job for you, by the way. Go scroll back. I did your job for you. We're remanding him into custody. You are. You're going to do it. I have a resolution. I have a motion, court-ready motion for you to remand him into fucking custody. I'm tired of this shit. That these articles are adopted as an emergency measure requiring immediate consideration under applicable rules. Rule 9, immediate vote. Everybody's going to get on the record. 3, that all matters referenced herein be formally referred to appropriate prosecutorial authorities like disbarment and inspectors general. We're going to rehire the ones that Elon fired for further action consistent with law. 4, that nothing in this resolution shall be construed as a finding of guilt in a criminal proceeding, but rather as the exercise of Congress's constitutional duty. You're welcome, Rick Rob. Come back for my enforcement of the 14th Amendment, resolution number 106. Just doing your job for you, Congress. Thank you for your attention to this matter. Here's a resolution for Congress to censure and remove itself. In the House of Representatives, a resolution censuring Congress, referring its members for professional sanction, acknowledging systemic constitutional failure, and calling for immediate restorative democratic measures, including snap elections and a formal apology to the American people. Whereas clauses, whereas members of Congress swear an oath to support and defend the Constitution of the United States against all enemies, foreign and domestic, yet have repeatedly failed to enforce Section 3 of the 14th Amendment, which bars insurrectionists from holding public office, and whereas following the January 6, 2021 attack on the United States Capitol, Congress seated and normalized individuals who aided, abetted, or provided comfort to an insurrection, thereby nullifying its own oath of office within days of swearing it, and whereas the Republican Party has been demonstrably captured by the interest of an adjudicated insurrectionist, a 34-time convicted felony, 34-time felony convict, it's like so astronomical, I can't even say it, and civilly adjudicated rapist whom Noam Chomsky has described as the worst criminal in human history, and whereas credible testimony, civil judgments, criminal convictions, and sworn statements, including recent explosive public testimony, have linked this individual to extensive criminal enterprises, including those associated with Jeffrey Epstein. He was the big boss, whereas Epstein was his manager, and whereas Congress has failed to initiate impeachment proceedings despite a multitude of flagrant legal and constitutional violations, a landslide of criminality and obstruction of justice, contempt of Congress and contempt for the rule of law, and as a result of Congress's stubborn refusal to hold him accountable, his latest distraction tactic is making repeated threats and actions advocating military aggression against allies, including Canada, Mexico, Greenland, and sovereign nations such as Venezuela, actions which would normally trigger immediate constitutional crisis response, and demands for psychiatric evaluation, especially since the world's mental health professionals have been clamoring for years about his mental, physiological, psychological, and moral unfitness and dangerosity, if that's a word. Whereas members of Congress certified national election results despite evidence that a federal contractor was permitted to spend approximately $300 million on election interference without a single objection raised on the House or Senate floor, and whereas such an action constitutes a deprivation of the American people's right to free and fair elections in violation of domestic constitutional guarantees and international democratic norms, and whereas peer democracies, including Germany and France, have taken affirmative steps to prevent similar interference, while the United States Congress elected passivity, and whereas Congress has stood idle while unlawful mass detention facilities described by human rights observers as concentration camps, including facilities such as Alligator Alcatraz, should be called Alligator Auschwitz, in Florida, have operated without constitutional due process. And whereas extraordinary renditions, unlawful deportations, and transfers to foreign detention sites implicate violations of the Geneva Conventions, the Rome Statute, and international prohibitions on torture. And whereas justice delayed is justice denied, and Congress's sustained inaction constitutes an ongoing betrayal renewed each day, and whereas attorneys serving in Congress and the executive branch are bound not only by constitutional oath, but by professional ethical duties which they have knowingly violated, and resolved clauses. Resolved that the House of Representatives hereby censures itself, collectively and individually, for a constitutional dereliction of duty, And resolved that the Congress of the United States formally acknowledges its failure to protect the American people from insurrection, corruption, rampant corruption, and authoritarian capture, and resolved that all members of Congress who are licensed attorneys be referred to appropriate bar authorities for investigation of professional misconduct and for allowing adjudicated insurrectionists, rapists, and 34 times convicted felon be sworn into office, and resolved that members of the executive branch and justices of the Supreme Court who provided aid or comfort to an insurrectionist be named for impeachment referral immediately, noting that congressional inaction does not confer immunity and that they be recused on this vote since the 200 GOP traitors who voted to overturn the election in 2020, they are recused on this vote since they are complicit in January 6th insurrection, should be impeached themselves. Resolved that the United States issue a formal public apology to the American people for the systematic erosion of democratic governance and failure to act or respond appropriately to any of a infinite number of disasters and countless people harmed and traumatized. We are all traumatized, so Congress needs to apologize for all the trauma it has inflicted on the American people by its failure to act and defend us. And we'll all get veterans benefits when I'm president. So we will all get veterans benefits when you elect me president in 2028. That is, if we have elections. Resolved that Congress calls for snap elections, supervised by independent international observers to restore democratic legitimacy, and resolved that credible allegations of crimes against humanity carried out by members and enablers and co-conspirators of this criminal, illegitimate misadministration be referred to the International Criminal Court, recognizing that no office confers exemption from international law, and resolved that the people of the United States reserve the right to convene Nuremberg 2.0 in the court of history, if not yet in law. I'm Trista, your interim president. I approve this massage. Give him help. Hey there, Jack Smith. It's me, Trista, the interim president and interim sheriff here in Tucson, Arizona. Guess what? I did your job for you. And I created a court-ready ready for filing motion to remand Diaper Chump into custody. Here, let's go. United States District Court, I guess it's Washington, D.C., right? United States of America versus Donald Chump, defendant, case number, Special Counsel's motion to revoke conditions of release and order pretrial detention. Introduction. We should have done this years ago, by the way. The United States, by and through the Special Counsel, respectfully moves this court pursuant to 18 U.S.C. subsection 3142F and 3148B to revoke defendant Chump's conditions of release and order his immediate remand into custody. Yay! Since being charged, the defendant has repeatedly demonstrated that he poses a clear and continuing danger to the community. That's an understatement. An unmanageable flight risk, especially with his brand new, spanking new billion-dollar taxpayer-funded Qatar plane, exacerbated by his refusal to comply with court authority and commission of new unlawful conduct while under indictment. No combination of conditions can reasonably assure the safety of the community or the integrity of these proceedings. Procedural background. Defendant is currently released pending trial pursuant to conditions imposed by this court. Those conditions include, inter alia, prohibitions against committing new crimes, obstructing justice, threatening or intimidating witnesses, jurors, prosecutors, or judges, and engaging in conduct that undermines the orderly administration of justice. Despite repeated warnings from multiple courts, defendant has escalated, not curtailed, his unlawful conduct. Legal standard. Under 18 U.S.C. subsection 3148B, the court shall revoke release and order detention if it finds probable cause to believe the defendant committed a crime while on release or clear and convincing evidence that the defendant violated any condition of release and that no condition or combination of conditions will reasonably assure the safety of the community or that the defendant will not obstruct justice. Again and again and again and again. The statute does not require speculation, it requires pattern, evidence, and risk, all of which are present here. Argument 1. Defendant poses a clear and ongoing danger to the community. Defendant's conduct is not abstract, rhetorical, or isolated. It includes public threats and inflammatory statements targeting judges, prosecutors, court staff, and witnesses connected to these proceedings. as well as anybody that says anything bad about him. Conduct that predictably incites harassment and intimidation by third parties acting on defendant's behalf. Repeated attacks on the legitimacy of the judiciary designed to undermine compliance with court orders. Courts have consistently held that indirect intimidation, when foreseeable and encouraged, constitutes danger to the community and obstruction of justice. Defendant's prominence magnifies the harm. His words function as operational signals to others. 2. Defendant has engaged in obstruction of justice and witness intimidation. The court may find obstruction based on statements targeting witnesses by name or description, attacks on cooperating individuals' credibility in a manner designed to deter testimony, statements intended to chill participation to judicial proceedings, and calling them up and threatening them with the loss of their lives or that of their family and loved ones. Defendant has shown inability or unwillingness to comply with lesser restrictions, including admonitions from multiple courts. 3. Probable cause exists that defendant committed new criminal conduct while on release. Probable cause exists that defendant committed additional offenses while under indictment, including but not limited to obstruction-related conduct, retaliation against witnesses, interference with the administration of justice. The statute requires only probable cause, not proof beyond a reasonable doubt. 4. Defendant is a serious flight risk. Defendant's risk of flight is heightened by the severity of potential sentences he faces, his demonstrated disregard for court authority, his access to extensive financial resources and international contacts, his repeated public statements signaling refusal to accept judicial outcomes. Courts routinely detain defendants with far fewer resources and far less incentive to flee. 5. No combination of conditions can reasonably assure compliance. The court has already attempted lesser measures, including warnings and limited restrictions. They have failed. Home confinement, electronic monitoring, or gag orders are insufficient where the defendant's primary weapon is public communication and his influence over others. Pretrial detention is not punitive, it is preventive. And here it is necessary. Judicial notice, limited and proper. Pursuant to Federal Rule of Evidence 201, the United States respectfully requests the court take judicial notice of the following adjudicated facts for purposes of assessing risk and dangerousness only. Defendant's multiple felony convictions in New York State Court, civil adjudication establishing liability for sexual abuse, the recorded telephone call in which defendant solicited Georgia election officials to find votes, threatened them to. Prior court findings concerning defendant's disregard for legal process. These facts bear directly on credibility, risk assessment, and likelihood of compliance. Public interest considerations. The Bail Reform Act expressly authorizes courts to consider the safety of the community as a whole, including protection of democratic institutions, protection of the judicial system, protection of witnesses and court officers. No defendant, regardless of status, is exempt from these principles. Equal justice under law requires equal application of detention standards. Conclusion. For the foregoing reasons, the United States respectfully requests that the court revoke defendant's conditions of release, order defendant remanded into custody pending trial, and grants such other relief as the court deems just and proper. Respectfully submitted. Special counsel. I'm doing your job for you, Jack Smith. You're welcome. Special Counsel, United States Department of Justice. Murka. I am here today not because I wanted power, but because power abandoned its job. When prosecutors refuse to prosecute, when watchdogs refuse to watch, when the law hides instead of standing tall, someone has to speak. And today, that someone is me, Trista DiGenova, your interim presidente and sheriff. Let's be clear, this is not about left or right, this is about law versus lawlessness. Jack Smith, Merrick Garland, you were not appointed to be historians. You were not appointed to be commentators. You were appointed to act, and instead you froze. While networks of insurrectionists walked free, while credible allegations of corruption, foreign entanglements, and abuse stacked up like cordwood, while the American people were told, just wait until the midterms. Wait for what? For democracy to bleed out quietly? From my perspective as a former psychology tutor at Oxford University, I recognize a familiar danger pattern. When a system enables pathological behavior, it doesn't calm it, it emboldens it. History teaches this lesson brutally well. Authoritarian movements don't collapse because people speak too loudly. They succeed because institutions stay silent too long. And let me say this plainly. Failure to investigate is not neutrality, it is complicity. When credible evidence, sworn testimony, whistleblowers' documents, and public records point to organized criminal conduct and the state shrugs, that is not justice. That is abandonment of duty. I am calling right now for immediate independent investigations, emergency grand juries, full release of sealed evidence, international referrals where jurisdiction applies, not vengeance, accountability. And Democrats, yes, I'm talking to you too. You don't defeat an authoritarian by whispering about norms. You defeat one by forcing daylight. Call the vote. Force impeachment debates. Make every representative go on record. If you're afraid to defend democracy publicly, then step aside and let the people replace you. As interim president and sheriff, my position is simple. If elected officials won't protect the Constitution, then the people will. We will not normalize insurrection. We will not excuse delay. We will not wait for tyrants to age out of accountability. History is watching. The world is watching, and the American people are done waiting. Jack Smith, do your fucking job. Merrick Garland, do your fucking job. Because if institutions fail, the people will remember who stood up and who stood down. America deserves courage. America deserves justice, and America deserves the truth. Now, not someday. Thank you. I'm Trista, your interim president, and I approve this massage. Give them hell. Call Congress switchboard 202-224-3121. Religiously demanding impeach the entire regime. Call for snap elections and give us a whole new government in a month's time. Sounds like a grand plan to me. Hi there, Merca. I'm your interim president, Trista, and House Speaker, and Pima County Sheriff. Scroll back to my Congress-ready resolution number 110 to disbar all the lawyers in federal government, and here we go on the Rule 9 privilege arguments. House ready. Tell Adelita Grijalva to sponsor it. So here we go. Rule 9 applies because this resolution implicates the constitutional integrity, dignity, and functioning of the House itself. Under House Rule 9, a question of privilege exists whether the conduct described directly affects the rights of the House collectively, its ability to discharge constitutional duties, or the integrity of its proceedings. Resolution number 110 qualifies as a question of the privileges of the House for the following reasons. Constitutional impairment. Licensed attorneys serving as members of Congress and officers of the United States allegedly have failed to enforce Section 3 of the 14th Amendment, thereby permitting constitutionally disqualified individuals to exercise power. This failure directly compromises the House's constitutional role in certification, oversight, and impeachment. Corruption of proceedings. When members who are licensed attorneys knowingly certify or legitimize unconstitutional governance, House proceedings themselves become tainted, misleading the public and undermining legislative legitimacy. Collective reputational harm. The House suffers institutional injury when its members, especially those bound by professional ethical codes, are perceived as enabling insurrectionary conduct and mass constitutional violations. Urgency and continuing harm. The alleged misconduct is ongoing. Attorneys remain in positions of authority, continue to influence policy and adjudication, and remain licensed without review. Delay would compound constitutional injury. Non-delegable duty. The House cannot outsource its duty to defend its own integrity. Referral for disciplinary action is a minimum remedial step necessary to preserve the constitutional order. Therefore, Resolution number 110 properly qualifies for immediate consideration under Rule 9 as a matter affecting the privileges of the House, warranting precedence over other business. Here's a one-paragraph media explainer for the lamestream media. Resolution 110 does not attempt to punish political beliefs. It addresses professional misconduct. The resolution formally refers all licensed attorneys serving in federal office to bar authorities for emergency ethics review, arguing that lawyers who knowingly enabled unconstitutional governance, mass deprivation of rights, and failure to enforce the 14th Amendment violated their professional oaths. Congress cannot disbar attorneys directly, but it can document findings, trigger disciplinary proceedings, and remove compromised lawyers from government service. At its core, the resolution asks whether lawyers who abandon the Constitution continue to practice law while governing the nation. They can't. Let's get rid of them all. I'm Trista, your independent interim president, House Speaker, and Sheriff. Have a great day. P.S. Here's 20 newsworthy brief story angles from the lamestream media. Can lawyers be neutral during an insurrection? A legal ethics reckoning hits Congress. Congress refers its own lawyers for disciplinary review. Unprecedented self-indictment of professional failure. Resolution 110, why Congress can't disbar but can still act. Civics explainer. The Untouchables, government lawyers' faith ethics collapse. Bar accountability finally invoked. Rule 9 triggered over lawyer complicity and constitutional violations. Why this jumps the legislative line. From oath to obstruction when lawyers enable power. Pattern-based ethics breakdown. Is silence professional misconduct? Congress says yes. Ethics theory meets practice. Extraordinary rendition on U.S. soil. The lawyers who signed off. Legal responsibility spotlight. Why Section 3 of the 14th Amendment is back and who ignored it. Historical context and current stakes. Disbarment as a democratic firewall. Why professional sanctions matter more than elections. Congress apologizes and refers itself. Institutional accountability moment. What happens when bar associations get a congressional referral? Process breakdown. Are judges immune from ethics? Resolution 110 says no. Judicial accountability debate. The legal profession's January 6th problem. Not rioters, enablers. Can democracy survive lawyers who treat the Constitution as optional? Big picture analysis. Math ethics referrals. Symbolic or substantive? Experts weigh in. Who guards the guardrails? Lawyers as gatekeepers or saboteurs? Why isn't this political retribution? Why this isn't political retribution. Ethics versus ideology. A government built by lawyers and undone by them. Structural critique. If lawyers won't enforce the Constitution, who will? Closing moral question. Final word. Just for you. Congress-ready resolution number 100. A resolution to impeach the entire federal government for chronic failure to govern. Whereas the United States Congress has confused holding office with holding press conferences, and whereas both major political parties have demonstrated an advanced allergy to accountability, courage, and basic arithmetic when counting votes, and whereas impeachment is treated as either a fundraising email or an abstract concept that last encountered in a civics class no one attended, and whereas the American people are trapped in a long-running hostage situation called bipartisanship in which neither side will cut the red wire, and whereas James Madison warned in Federalist number 10 that political factions would endanger the republic, and America replied, cool, let's try 2 permanent ones, funded by billionaires. Whereas the Constitution has been repeatedly invoked as a prop, a shield, and a suggestion, but rarely enforced, resolved that the House symbolically impeaches itself for criminal levels of inaction, the executive for executive overreach, treason, domestic terrorism, state terrorism, and reality distortion, the judiciary for mistaking lifetime appointments for lifetime immunity, resolved that the American people are formally apologized to for letting this go on far too long, gaslighting voters with phrases like norms, decorum, and after the election, treating authoritarianism as a branding exercise. Resolved that snap elections be demanded by the public within 30 days, supervised by independent observers, sunlight, and adults. Resolved that money be removed from politics and replaced with ideas, debates, and the ability to answer a question directly. Resolved that term limits be imposed so aggressively that Congress briefly remembers what it feels like to miss a job. Resolved that the author of this resolution is explicitly exempt, having neither held power nor refused to act while holding it. Members of the House, what are you waiting for? Because whatever you think this moment is, it is not normal, it is not sustainable, and it is not what you swore an oath to defend. You did not swear an oath to a party, you did not swear an oath to donors, you did not swear an oath to delay. You swore an oath to the Constitution of the United States, and many of you violated it the moment you certified power without enforcing the safeguards that Constitution demands. Let's be honest with the American people for once. You knew the risks, you knew the record, you knew the warnings, and you chose inaction. Justice delayed is justice denied, and Congress has made delay an art form. You allowed an adjudicated insurrectionist by the plain language of the 14th Amendment to walk back into power without completing the constitutional review you were obligated to conduct. You allowed massive, unprecedented political spending by a federal contractor to flood our elections, then looks the other way while the ethics infrastructure designed to prevent corruption was dismantled, defunded, or ignored. And let me be very clear, this was not accidental, this was enabling. You do not get to claim shock now. You do not get to wring your hands and say, if only we had acted sooner. You had years to impeach, years to enforce Section 3 of the 14th Amendment, years to protect democratic guardrails instead of treating them like optional suggestions. And while Congress debated optics and polling, the consequences landed hard on real human beings. We now live in a country where investigative journalism and human rights reporting raise serious questions about unlawful detention, abusive conditions, and the outsourcing of punishment beyond public view, where allegations of concentration camp-like conditions are not dismissed with outrage, but with silence, where oversight is obstructed, ethics offices are weakened, and accountability is treated as partisan warfare instead of a constitutional duty. This is not democracy, that is decay. So today, as House Speaker, in satire, yes, but with deadly seriousness, I am done waiting for permission to do the job you were elected to do. I'm introducing Congress-ready resolutions, written, formatted, and ready for immediate votes, calling for enforcement of the 14th Amendment, removal of officials who enabled insurrection, disbarment proceedings for attorneys who violated their professional oaths, full restoration and funding of congressional ethics enforcement, immediate impeachment proceedings for ongoing abuses of power, emergency measures to restore democracy, democratic legitimacy, and emergency proceedings to transition back into democracy and hold emergency snap elections. And yes, snap elections to fill seats vacated by those who forfeited the public trust. If democracy is worth defending later, it is worth defending now. If elections matter next year, they matter this year. And if Congress will not act because it fears the political consequences, then let me remind you, the consequences of not acting are already here. To the American people, you are not crazy. You are not imagining this, and you are not powerless. This House can act today. The resolutions are written. The evidence is public. The Constitution is clear. So again, members, what are we waiting for? I'm Trista, your interim president. I approve this massage. Have a blessed day, all. Congress is very busy fundraising, busy blaming, busy explaining why now is not the right time to act. Again, so I did what any exhausted citizen would do in a functioning democracy. I wrote the resolutions myself, not because I want power. God, no, I retired from the 9-to-5 grind years ago to become a volunteer, which is apparently more than can be said for the people drawing congressional salaries. This isn't ambition, it's triage. When both parties refuse to enforce the Constitution, that's not moderation, that's negligence. When accountability becomes a partisan sport, democracy becomes a spectator event. And when no one is willing to pull the emergency brake, eventually a civilian reaches for it. That's me, clipboard in hand, democracy in distress. James Madison warned us about factions. We turned them into corporations. The founders feared tyranny. We rebranded it as electability. So yes, I wrote impeachment resolutions, not because I'm special, but because Congress isn't doing its job. Someone had to notice the building was on fire. In response to years of constitutional paralysis, partisan cowardice, and performative governance, civic volunteer and public watchdog Trista Di Genova, that's me, has released a series, 100 plus, in fact, released on my Substack, Trista Di Genova, a series of satirical Congress-ready resolutions demanding accountability, snap elections, and a government that functions. These documents are satire, but the crisis is real. When elected officials refuse to act, citizens are forced to remind them what their job is. The resolutions call for enforcement of constitutional checks and balances, an end to permanent political factions, emergency elections, accountability without party protection. Citizens are encouraged to share the resolutions freely, call the congressional switchboard at 202-224-3121, demand action, not excuses. This is not radical. It's remedial civics. I'm Trista, your interim president, and I approve this massage. Have a blessed day, y'all. And give them hell. Impeach them all now and send them to the fucking Hague.
I asked for 5 minutes of Congress's time. I didn't ask for power, I asked for 5 minutes. 5 minutes to remind Congress that democracy doesn't run on autopilot. 5 minutes to say what happens when institutional freeze and citizens are told to wait quietly while everything burns politely. I'm a comedian posing as an undercover investigator on behalf of the public, which frankly shouldn't be necessary, but here we are. I recently graduated with the 4.0 from HMI because if the country is going to gaslight itself, someone should at least be trained to